Welcome to this, the most recent of our Talking IP sessions. The subject of today's session is fashion, IP and fashion, and we've attracted a fantastic panel of guests with very different perspectives on the question to talk about it. As you may have just heard at the beginning, this session is being recorded, so if any of you want to revisit any of the points that are made, it'll be available on our website from shortly after the end of the session. Our panel today, so the session is mostly being run by my colleague Nikki Hanglin, who runs our trademark prosecution practice. She's duly qualified as a trademark attorney and solicitor and leads our filing practice. Also with us, Gillian Ridley Whittle, who was fashion director for Topshop and has now set up the lifestyle brand Peach House, so a view from industry. Very happy to be joined by Johnny Moss, who's a dual UK and US qualified barrister at Hogarth Chambers. Johnny recently represented the UK government in the Coffermel case, which, as we were just discussing before we started, is probably the most important copyright case in the UK since before I was a lawyer, so a long time ago. And Bob English, who is an attorney at the US firm Cowan Liebowitz and Lattman. Bob's got a fantastic range of high-end fashion clients amongst his clients, and is joining us to give us a US perspective. There will, during the course of the webinar, be some polls. Please do feedback on the polls, they'll help inform the conversation. And finally, we'll take questions at the end. If you've got any questions, you can put them into the chat function, and we'll pick them up, as I say, in the Q&A session at the end. So with all of that, I will leave you in the safe hands of Nikki to start the conversation. Nikki, over to you.
Thank you, Mark. Good afternoon, everyone. Thank you for joining us today. Now, before I start talking to our speakers, I'd just like to run our first poll. So the question is, do you think that IP protection in the fashion sector is fit for purpose? Is it too weak or too expensive, favouring infringers? Is it too strong, favouring major designers' labels? Or is it about right? Okay, that's interesting. So most people so far are thinking it's too weak and too expensive, favouring infringers. So 73% think too weak or too expensive, favouring infringers. 7% think too strong, favouring major designers' labels. And 20% think it's about right. Okay, so I'm going to start now by talking to Gillian, then move on to Johnny, and then bring in Bob at the end. And then finally, as Mark said, we'll have some questions at the end, so please do send in your questions. So Gillian, good afternoon. Thank you for joining us today.
Hi.
I'd just like you to first, perhaps if you would, tell us a little bit about your experiences working in the fashion industry, and then tell us about your really exciting new venture.
Yeah, so thank you, Nicola. I've worked in the fashion industry now for over 25 years. I started off doing a fashion design and marketing degree, and I was a graduate at Marks and Spencer's, and then worked my way around the industry, a stint at a company called Bay Trading, then Debenhams, then back to Marks and Spencer's for my second stint. And during that time, I've worked in women's wear, underwear, beauty. I also went to Australia in 2014 for 4 years, where I ran the women's wear businesses for Target. I also worked for Maya, running their beauty halls, kids wear and underwear business. And I came back to fashion director at Topshop, which was my last corporate role before my very exciting new venture, which is actually something I've always wanted to do. I said, when the time is right, I'll set up my own brand. And when Topshop was taken over by ASOS earlier this year, I was made redundant, and someone who I'd been talking to about a brand that I'd created decided to invest. So my brand is called Peach House, and we launched in January, and it is a lifestyle brand selling underwear, lifestyle clothing, sleepwear, and swimwear, and it's very lovely. Obviously, I'm going to say that. Very excited.
I will second that. It is very lovely. In your previous roles working for those companies such as M&S and Topshop and Target, what were the approaches there to intellectual property protection, and did it differ much between the various companies?
So I would probably say, because the companies, particularly Marks and Spencer's and Topshop, are quite high profile for various reasons and very much in the public eye, IP protection actually was quite important. During my years in the industry, actually, the focus on IP has become a lot more visible for the buyers and the designers than it was when I certainly started as a graduate. It's become more important, and there were lots of myths about actually what was acceptable and what wasn't acceptable in terms of interpreting other people's designs. So some of the things that we would do is trademark protection, patenting some of our innovations, for instance, at Marks and Spencer's on bras, which we put a lot of time and development into those, and we didn't want to be copied, particularly as we were a market leader. And then obviously design registration, if we had some real iconic designs. Topshop used to IP or take out trademark protection on the names of their jeans, for instance, because they were, some of the biggest selling jeans in the country.
Thank you. That's really interesting to hear about the different types of IP protection there. Now, in your experience, do you think that copying of designs is a problem needing to be addressed, or do you think there is a certain expectation of deriving from earlier designs in the fashion industry?
It's a really interesting question. Instinctively copying doesn't feel right at all, but we all in the fashion industry follow the same trends, get the same information from, whether it's forecasting information, or in the past before COVID, shopping New York or LA or Tokyo, and you're always exposed to lots of other people's work, and influence is taken from that. And I think the skill is actually being able to interpret some of the things that you've seen, but done in an original way. So direct copying, in my view, is wrong. It shouldn't be done. And particularly if you're looking at, say, a small designer who actually is funding themselves, they are putting a lot of their own design integrity, design intelligence into their work, and then to have a retailer who's got big buying power just copying that and actually making money out of that, it's just really not, it doesn't feel right to me, not in today's age. And I think to beat brands today, to really stand out, need to have an original design intelligence and an IP that they own.
Yeah, no, I completely agree. And can you tell us about any particular instances of copying that you've come across, and perhaps how they were resolved?
And this is quite an interesting one. I've actually got 3 examples to talk about today. So 2 were actually at Topshop, and 1 was in the past at Marks and Spencer's, which is a very publicised case. So the first one was Lisa Bruce, who's a swimwear designer. This was a few years ago now, when I was at Marks and Spencer's, had come up with her own range of swimwear designs, a swimsuit. And when she in her own research on the high street, saw that Marks and Spencer's had a swimsuit which was very similar to one that she had actually designed herself. And as a small designer, she felt that she was within her rights to actually go and take Marks and Spencer's to court over what she believed at the time was copying her work and her design. I don't remember what the outcome of that case was, and I have looked it up, but I couldn't find it. But it was an example where something was visibly close. Another one for me, which is actually one when we were at Topshop. So Topshop were producing T-shirts where they were putting on the names of either other cities or other countries, and one which they put on was Kyoto on the front of a T-shirt. Now, I remember, because we got a letter from Superdry to say that they were advising us to remove it from our sales floor, otherwise they would take further action, which we did in due course, quickly. And then a third one, which was really interesting, and that's probably a little bit related to fashion today, which is there's a big fashion for heavy shoes and footwear. And Dr. Martens have been very clever over the years, and they've patented the design of their sole, the unit of their shoe and their boot. And it's the lines of the rubber, which are imprinted, go a certain way. And we at Topshop, as had actually many other high street footwear retailers, had used a very similar unit with the lines going a certain way, and Dr. Martens, rightly so, were protecting their rights. So actually we did actually have a case against us in Belgium, I think it was. But there's 3 examples actually where, and they were quite innocent, you know. I think particularly the Kyoto one and the shoe one were quite innocently entered into from a designer's perspective. So it shows how easy it could be to get it wrong.
So as a fashion brand owner now, how do you think you can lessen the risk of infringing third-party IP? I know you touched on it briefly earlier about myths.
Yes, so this is an interesting one. So when I grew up, we thought that there was only 5 things that you needed to change to make something okay to interpret. So, and we were trained, this is at Marks and Spencer's, and that was one of the biggest myths that was blown, which is a load of rubbish. It's not about 5 things at all. So, although I'm sure we'll talk about that later, it was something that actually was quite revealing in terms of what we all thought. But training is really important, and certainly Topshop and Marks and Spencer's took that very seriously. They were too much in the public eye and couldn't afford any expensive cases against them.
Yeah, no, it's very it's obviously very important to educate your team as to what intellectual property actually is.
Yes, absolutely.
So finally, do you have any top tips to think about when coming up with a new brand?
First thing is obviously trademark your name in the countries and the classes that you want to trademark in, and anything obviously which is particularly pertinent to the design of your branding. But really for me now, you know, I think it's an interesting time in fashion. I kind of call it the industrial revolution of the high street right now. And really for any new brand, a sense of purpose is really important. So really understanding, you know, what you're going to do. All the research groups I do, authenticity is really, really important, and visibility throughout everything you're doing. Putting the customer first, and being really clear of what you want to deliver and your timelines, I would say.
Thank you so much, Gillian, for those really interesting insights into the fashion industry. Please do stay on for any questions at the end. I'd just now like to ask Johnny a bit about his experiences working in the fashion industry. Good afternoon, Johnny. Thank you for joining us. Could you just start perhaps by telling us a bit about the types of clients that you've worked with in the fashion industry?
So I've worked with all types of clients in the fashion industry. I used to do quite a lot of work with M&S. I did work for Agent Provocateur. I've worked for a number of the fast fashion brands in the past few years, Gucci and others. So all different aspects of the fashion retail chain.
And have you seen any changing trends in approaches to copying of designs and also litigation amongst fashion brands?
Yeah, so as Gillian mentioned earlier, there is inevitably in fashion a certain amount of copying, for want of a better word, that goes on, because to set a fashion trend, you need to be followed. And of course, the question then becomes, what is following a fashion trend and what is copying a fashion trend? And the reality is that certainly in design and copyright terms, what would be deemed to be following often is probably legally and technically copying. But it used to be the case that obviously it would be the high fashion brands, the Chanels of this world, that would be setting the trends. And they tended not to sue downwards to the sort of high street brands or the cheaper brands, because you want it to be followed. You know, Burberry doesn't want to sue somebody who's picked up on something they've done necessarily, unless it is a sort of direct ripoff. So because of that, you tended not to get too much litigation. What I've noticed recently is that a lot more innovation now is coming, particularly amongst the fast fashion brands. A lot more innovation is coming internally and then being picked up by their competitors. And because, of course, they're on the same level, you get a lot of litigation between them now in a way that you didn't. So it used to be sort of asymmetric. You had the high fashion brands choosing not to sue downward, shall we say, to the high street brands. But now you have people effectively on the same level who are creating designs. And obviously in fast fashion, something gets picked up and you know it's successful very quickly. So there's a lot more litigation there than there was even 4 or 5 years ago. And also fast fashion being so profitable has meant that actually it is worthwhile fighting and litigating. And then the final thing that I've noticed recently in the past 5 or so years is companies using intellectual property litigation as effectively a marketing tool. For example, a full page advert. If you take the third page in the Sunday Telegraph, that's, can be up to £100,000, I understand, for a full page advert that is so prominent. And in one case I was involved in a number of years ago involving trunky suitcases had effectively 3/4 of that page that arose out of some litigation they were involved in. And that was very carefully placed. And obviously, if your story is being placed, you're not having to pay for that. So, and the best example of that recently is the Colin the Caterpillar case. No doubt everybody here has heard about Colin the Caterpillar. And people are now aware that Marks and Spencers are willing to sue people over it. The merits of that case are almost insignificant because the amount of publicity that they got out of the back of it. So again, and this is particularly for the fast fashion brands, they're using quite cleverly, in my opinion, litigation that they're bringing themselves to show either that they create designs, or if they're on the defendant side, they're showing, hey, you can get your stuff here, but cheaper. So it's being used a lot more tactically now, in my opinion.
Yeah, it can be very clever marketing.
Yes.
So now you acted for the UK government in, Mark mentioned this earlier, the very high profile Coffermel case, which is a referral to the Court of Justice of the European Union by Portugal. And it was in relation to copyright protection. So it was in the context of a dispute between two companies over the copying of designs of T-shirts, jeans and sweatshirts. And the impact of this decision is potentially really far-reaching for design owners. So could you just tell us a little bit about your involvement with that case, please?
Yeah, so it was involving G-Star, and prior to the Coffermel case, the view was always that if you wanted to protect clothing, it had to be protected through design right. You can have registered design right, but registered design right usually isn't that common for fashion because it's too expensive to register everything. And therefore it would be protected by unregistered design right, of which there are 2 types. One used to last for 3 years and the other could last for up to 10 years. And therefore you were somewhat limited. And also under design law, there was various restrictions. You couldn't register certain things that were commonplace and functional. And that was the view. Everything in fashion was only covered by designs prior to Coffermel. What the Coffermel case was about was whether or not actually you could apply copyright law to these sort of things. Could copyright subsist in a pair of ripped jeans, for example? And the reason that you might want copyright to apply is that copyright doesn't have any of these exclusions. So there's no restriction on what you can cover by copyright. And also copyright lasts for the life of the author plus 70 years. So it's also a lot longer. The UK government intervened because the copyright law in Portugal was very similar to our law. Under our law, you couldn't get copyright protection in something like clothing because the only sort of 3D items that could be protected by copyright either had to be works of artistic craftsmanship, which clothing were not, or sculpture. Those were the only 2 bits of copyright law that protected, for want of a better phrase, 3D things. The Coffermel case in the Court of Justice said, no, you can't do that. The only test for whether copyright subsists is whether the thing, whatever it may be that has been created, embodies the author's own intellectual creation. So coming out of that, clothes now arguably are protected by copyright in a way that a few years ago they were not regarded as being so protected.
So what does this mean potentially for design owners? So I guess it's good news that there are potentially wider categories of work that can be protected by copyright, but also there's quite a lot of uncertainty at the moment in terms of how UK copyright law is actually going to be applied.
Yes, so there was a decision involving the Edinburgh Woolen Mill, which looked like it may answer whether or not Coffermel was going to be applied so broadly here, but unfortunately Edinburgh Woolen Mill went under. That case was off on appeal, and therefore the appeal disappeared, so we don't know. Ultimately, it's a very double-edged sword, because as I said earlier, if you have a very good design, then great, you can get protection for a lot longer period than you could have before. But of course, you also now have to be somewhat scared, even as a designer, because if you're taking something from a garment that is from the 1970s then all of a sudden that garment may now suddenly be, covered by copyright again. So it's a bit of a double-edged sword. It's led to a huge uptick in litigation involving COFML. And many of these cases have not fought yet because people are uncertain as to the way in which the courts will apply it. It does apply at first instance over here, and it's going to take a Court of Appeal case to say whether it does or does not apply post-Brexit. But at present, it still applies post-Brexit. But again, if it's the life of the altar plus 70 years, the minimum you can go back is 70 years worth of clothing from now is protected, and obviously even further back than that. So potentially very wide reaching.
So did you say you have seen a big rise in copyright cases since?
Yeah, so there's been a huge rise in what we call COFML type cases, and covering not just fashion, but any 3D item. There was the Edinburgh Muller Mill case, which was involving the sort of tartan patches and swatches like that. There has been a number of cases involving sort of very fancy cafetières from the sort of 60s and the 50s, furniture, a lot of litigation over sort of designer furniture, particularly Scandinavian furniture. And as I said, fashion as well. So a lot of litigation has been instigated. But often these cases are not worth huge amounts of money. They're certainly worth beginning litigation over, but maybe not worth fighting all the way to the end. And therefore, both sides end up coming to a commercial settlement. But nonetheless, that lack of certainty means that settlements are probably a little bit higher than they should be. But often that just means there's a bit more pressure to get it sorted and get it done. So yes, I have seen a very large uptick in this type of work since the COFML decision got handed down.
So going forward, now that the UK has left the EU, do you think that the decision ultimately will be followed by the UK courts? I know that, until it gets the Court of Appeal, they have to follow it. But at that point.
So my view, and I think certainly the view of most of my peers at the bar, is that COFML is wrong, that it's incorrect, and it's in breach of international law. You can take that with a pinch of salt, because obviously I was arguing that in the Court of Justice. But there are a number of international treaties. The Berne Convention, for example, says that member states have discretion to set the threshold of artistic merit for these type of things. And that was basically the argument the UK government ran in the CJU. It was that under international law, we have the discretion to set the threshold. Therefore, we can set a discretion. The Court of Justice effectively said, yes, you do have a discretion, but we're telling you how to exercise it. So I think that it will get overturned. But as I said, it will have to go up to the Court of Appeal. Whatever case goes to the Court of Appeal will probably go on to the Supreme Court, because it's such an important matter. Ultimately, I do think it will be overturned, but it will be quite a few years before that happens. And then I think the other thing to point out is that in the background, there's also been this much consideration and discussion over the possibility of a new Copyright Act. We tend to have a new Copyright Act, give or take, every 30 or 40 years. 1956, 1988, we're definitely due one now, and there's been so many changes. It has been discussed. The UK IPO has said they're considering it. It was discussed during Brexit and whether or not we needed it post-Brexit. I'm somewhat hopeful it will happen. I don't think it's going to happen imminently. I've certainly not heard it being started drafting, and obviously it's going to be a very long process. But so I think it will change, but I certainly think we're stuck with it for a number of years yet.
Okay, it will be very interesting to see what happens next. So, and finally, do you have any top tips for fashion brands on things they can do to assist with enforcement of their intellectual property?
Yes, so one of the things when I was doing some work with Agent for Couture, they did so well is they had kept amazing records and catalogues of all their competitors and everybody else in their market sector. And of course, when you're looking at the details of clothing and fashion, it's often having to look at which bits are actually common, which bits have been found elsewhere. And those are the sort of things you think, oh, that's very common, but it may be, but proving that feature is very common is difficult. You need evidence, and the best evidence for that is catalogues. And they were very good because they kept catalogues going back years. So I was just dumped with a whole load of copies of the catalogues that they'd taken and been through. Nowadays, you obviously don't get hard copy catalogs, but obviously it's very hard to find stuff on the internet after the fact. And therefore, what a number of my clients have been doing is basically, as they go every season, just making sure that all their competitors' websites are screenshotted, or their catalogs, if they have it, are recorded and just popped in a file on a computer saying, spring 2021 fashion trends, and it sits there. And hopefully that folder never has to be opened and used. But if there is any litigation, then having access to that is very useful. And the reality is that the designers are often looking at this stuff anyway. So all it's doing is actually getting them to keep a record of everything so that they have it. So that would be the one tip that I think, if you ever do get involved in litigation, is a very easy thing to do, very cheap thing to do as you go along. But if you then have to pay the lawyers 5 years from now to do that same exercise, it will cost an awful lot more money than if it's just done as you go along.
Yeah, that's a really interesting tip. Thank you. And I bet that made for some interesting reading in the agent provocateur case. Thank you very much for sharing all your insights with us, Johnny. It's been really interesting. Please do stay on for questions at the end, and please keep your questions coming in. So now, before I speak to Bob, I'd just like to launch the second poll, please. So, firstly, do you have any experience of operating in the US market? Yes or no? And then, do you think it offers greater or lesser protection than Europe and the UK? Greater, lesser, or you're not sure? So 24% have had experience of operating in the US market and 76% haven't. 24% think it offers greater protection than Europe and the UK. 35% think less, and then 35% aren't sure. 6% not applicable. Okay. Good afternoon, Bob. Thank you very much for waiting, and thank you for joining us all the way from New York today.
Thank you, Nikki. My pleasure.
So could you just perhaps start by telling us a bit about the types of clients that you act for in IP matters in the US?
Sure. Well, I represent a number of different brands and companies in connection with IP matters and trademarks in particular. I am fortunate enough to represent a lot of very exciting fashion brands as well. And in particular, maybe most notably, we do the worldwide trademark coordination and management for Gabrielle Studio Inc., which is the company that owns the DKNY and Donna Karan brands. We also work for an American retail company called Buckle Brands, which has many stores throughout the US and also sells internationally under the marks Buckle, as well as several house brands that they've developed. And then, we represent all other kinds of brands down to startups and smaller fashion brands. One brand that I'm particularly excited about these days is a brand called Noah Clothing, which has sort of an international presence. And we also, as a firm, represent other sort of, well-known fashion brands like J. Crew, Warby Parker for eyewear, and other beauty brands as well.
And what type of IP rights do your clients operating in the fashion industry typically protect?
Sure. As Gillian mentioned earlier, the trademarks for your name are really the most important. Our IP protection that we see for fashion brands. It's important to get that right from the start. But beyond that, many of our fashion brand clients do seek to protect other branding elements. So that could be product names or taglines or other sort of logos. And then we do get into design protection on some level. Now, the US does not have a design right in the same way that there is in Europe. But we do have, the ability to protect designs on some level using the other areas of IP, such as copyright, design, patent, and even with trademarks to some extent as trade dress protection. So we do see some of that. And in fact, there are many US fashion brands, particularly in the footwear industry these days, that are focusing heavily on trade dress protection as a registered trademark right.
There are quite a few differences actually with US IP protection, aren't they? I mean, one of them you touched on, you can register copyright in the US, whereas you can't in the UK. Also in the US, there are two different trademark registers. There's the principal register and the supplementary register, whereas in the UK and the EU, there's just one register. Could you perhaps just tell us a bit about how that works and the differences between the two?
Sure. Yeah, the supplemental register in the US doesn't come up so often. It really only applies to marks that lack distinctiveness but are capable of acquiring distinctiveness over time through use. So a generic trademark can never be registered, but a trademark that's considered merely descriptive, it's possible that it can be registered at some later point in time on the principal register if it acquires secondary meaning, or what we call acquired distinctiveness. But obviously that takes time in most cases to do that. So the USPTO does allow registration for, as I mentioned, marks that are descriptive but not generic, that are capable of acquiring distinctiveness over time. And it can be useful for some brands who are really who are intent on gaining a broader scope of protection for a mark that may be descriptive at a particular point in time and are essentially in it for the long haul. They're going to use the mark. They're prepared to brand around a mark that needs to acquire distinctiveness in order to have stronger protection. And what you can do is you can register that now on the supplemental register, provided that the mark is in use. This doesn't apply for marks that are not yet in use in US commerce. And over time, if the mark acquires distinctiveness, you could then reapply to register that mark on the principal register. Just quickly, the disadvantage is that a mark on the supplemental register isn't entitled to the same presumptions of validity and ownership and exclusive, and you don't get this sort of exclusive rights that you would with the principal registration. But it is an important tool for brands that are in this situation because it will block others during examination at the USPTO. And it also puts the rest of the world on notice that you're out there and that you have a brand that you're developing that you consider yourself to have trademark rights in. So it has some value in that sense.
And am I right in thinking if you move from the supplemental register to the principal register, you don't take your earlier filing date with you?
Yeah, so I mean, you can always claim the benefit of your earlier use. In the US, we recognize common law rights, and trademark rights are based on common law, but it isn't sort of a priority. It would be a separate application filing date. So if you are considering the strategy of, you have a supplemental registration, you want to later apply on the principal register, you might consider with your trademark attorney how to handle the timing of that. But you would still claim your first use date going back to the original day you introduced use, which, keep in mind, could predate the date you filed in both the supplemental register application. So yeah, and we see that sometimes this is beneficial just to tie it in for design for trade dress protection, because a lot of trade dress requires acquired distinctiveness in order to be registered. And if you don't do that because it's a new design, then you might consider whether you should at least obtain something on the supplemental register for now.
Yeah, that's useful. So how important is it to protect your IP rights in the US, and when should you do this ideally?
Sure. In the US, unlike many countries, we are not a first to file jurisdiction in the US. So on the one hand, brand owners who are using a mark already have some level of protection. If you're using your mark in the US in connection with your goods, you probably can claim common law rights on some level. So unlike countries where it is very much a race to the register, that's not usually the case in the US. At the same time, you gain a lot of valuable additional protections for doing that. The scope of common law rights are relatively narrow in the US. And so if you are entering the US market or are already in the US market, you do want to be registering your trademarks. I wouldn't rely exclusively on common law rights if you can avoid it. So I do think that if you're in the planning stage or have already launched, then you should register certainly your trademarks, your names sooner rather than later. And one very beneficial aspect of trademark prosecution in the US, as you may know, is that you can file based on intent to use. So you don't have, even though use is ultimately a requirement in order to obtain a registration in the US, if you are in the planning phase, you can file that application sooner, essentially holding your, constructive priority date based on your application, and then perfect your use later. So it's really a great resource for brands that are just starting out that maybe aren't in the US market yet, but plan to come to the US market soon.
And in your experience, what can happen if you don't apply to protect your trademark quickly enough in the US?
Sure. Yeah, so I'll address it both as to the US and generally. So as I mentioned, because you have common law rights, if you're already using in the US, you could have a situation where if maybe somebody beats you to the register, but you have priority, and you may be able to challenge the other party, the sort of the junior user's registration. But that makes the process a lot more complicated and expensive. At that point, you're talking about administrative cancellation proceeding, possibly, where you're trying to say, hey, yes, you got to the register first, but we've been actually selling here for 5 years. So we have priority and you have to stop or have whatever the parties will work out between them. Obviously, these things settle often. But so if you don't register quickly, there are still ways to do it, but the consequence can be that you have to sort of clean up the situation later. Obviously, outside of the US, where most countries are first to file jurisdictions, if you don't register quickly enough, you very well could have a situation where somebody's gotten there before you, and that person will then gain a legal right to use that trademark, whether it's a piratical copy of your trademark done in bad faith, or even just an innocently adopted or same or similar mark. So it creates a lot of headaches, has been my experience, especially for our US clients as they expand overseas, when we discover that, while they have a robust trademark portfolio in the US, they have no rights overseas, and also considering that most countries don't really recognize common law rights, right? So even if they were using in some of these international markets, that doesn't give them any rights as against someone who registers before they do.
Yeah, there's a particular problem in China.
That's certainly been my experience.
So due to the increase in online activity, online sales, have you seen that there's any kind of differences in filing strategies or more engagement generally in protection of intellectual property?
Sure. I think, going back to what we were saying about the timing of when you file, whenever you have an online presence for your brand, even if it's just marketing pre-launch, and it's on the internet, the world is seeing it. And even if you don't have a physical presence or any sort of commercial presence in a foreign market, there may be others in that market that are looking at this and saying, I think we should be that brand before they get here. And we do see a lot of piracy, which I think is moving much, much more quickly these days than it was, 10 or even 5 years ago, because of sort of the increase in online presence. And I've just noticed, my own sort of personal experience has been that in places where piracy is prevalent, that there is, even relatively young or small brands that aren't even necessarily that well known in their home markets, are already encountering piracy in ways that, you wouldn't necessarily have anticipated that. So it is an issue, and it is something that, in terms of filing strategy, does drive a need. And certainly as an IP attorney, it's often my recommendation to seek registrations in at least your core markets, where you're already selling, where you plan to sell. The big, for budget reasons, this could maybe just be limited to your bigger commercial markets, as well as maybe places where you manufacture, and also places where there's just known to be high piracy. And China is a good example. I mean, I counsel a lot of startup fashion brands that the idea of having a retail presence, whether brick and mortar or online even, in China, it doesn't seem important to them. But if they don't do that, and then they have a piracy issue in China, the cost of trying to deal with that can really be astronomical. So it's money well spent in a way to consider whether you should be pursuing defensive filings early on. And I think that's all been accelerated in recent years with the prevalence of online sales and marketing.
And with the global portfolios that you manage, where would you say that you're seeing most enforcement activity at the moment? I know we've already said China is probably at the top of that list, but in terms of other countries, what would you say?
Yeah, China continues to be sort of the biggest. I think, unfortunately, we tend to see some of the highest rate of bad faith filings in there coming from China, but we see some of those types of filings as well in other parts of Southeast Asia, for example, Vietnam, Indonesia. I've seen, I would say the last couple of years, I've seen an uptick in the Middle East that we didn't quite see before, including for, obviously piratical filings. Some of my larger fashion brand clients already have thousands of trademarks globally, and so they have fairly robust portfolios. But, so I'm always a little surprised when I see a piratical filing in a country that isn't, so common. Like recently I've seen more piratical filings in places like Yemen, which don't really come up very often in terms of our regular enforcement activities. As well, some countries in Latin America have generally been hotspots. I have seen increased activity in Europe as well, but not for what I would consider to be a bad faith or piratical filings. Occasionally we do see that, and I have seen some real attempts at doing like a knockoff, but I think a lot of it is just, there seems to be a lot of activity, a lot of filing activity in Europe, and so that tends to lead to a little bit of increased enforcement in the area. Yeah.
And so what would your advice be for a fashion brand looking to expand into the US?
Sure. I think, as I mentioned it before, the intent to use process, which is really valuable. When we think about expansion, if you're not in the US, but you want to be in the US, if you can file an intent to use application before you get here, that's a good thing. Like I said, you'll sort of secure a priority date. But also, even before you get to the point of filing, doing a proper clearance search in the US is also really important, because it's not just simply a search of the US register to see what's pending or what's registered already. It's also really necessary to do at least some level of common law search on the internet. And this is, usually is just a robust internet search. There are vendors who supply search reports that dig a little deeper. They look at company name registrations and domains and things like that. I mean, the truth is we're talking about the internet, so there's sort of no end, there's no horizon really, right? You can search forever, and so you may not ever definitively rule out or definitively clear a trademark for use in the US. But as we all know, I mean, if you do a robust search and you can't find anything that's similar within a reasonable number of hits or pages of Google or whatever you want to do, then that strongly suggests that the risk may be lower. So what it really is essentially like a risk mitigation exercise. You want to make sure there isn't someone else who's already using the same or a similar mark for your goods or for related goods or services that's already established in the US. Because if you come to the US and you've searched the register and it looks clear, but there is someone who has prior common law rights, those rights are very well could be, sufficient for that person to sue you in court for trademark infringement, even without a registration. So it is something that's important. And when we do a lot of work for foreign companies looking to come into the US, we make sure that we do at least some level of searching on a common law level in addition to the register. So I think I would definitely caution a brand looking to expand to consider that.
Thank you. Yes, I think it is important not to forget about common law searches. So thank you, Bob, very much for your very useful advice today. And thank you to all our speakers for joining us today. Before we go to our questions, I'm just going to launch our final poll, if I may. And this is actually a rerun, almost a rerun of the first one. So we're just going to see if your feelings have changed now that you've heard from the speakers. So having heard from the speakers, is the current system in terms of IP protection and enforcement generally fit for purpose? Do you think it's too weak, favouring infringers? Do you think it's too strong, favouring major designers' labels? Or do you think it's about right? So we'll just give that a little bit longer. It does look at the moment like your answers may have changed since earlier, which is interesting. So 28% of you, as opposed to 73% earlier, now think it's too weak, favouring infringers. 11%, so roughly the same as earlier, think it's too strong, favouring major designers' labels. But now 61% of you, when earlier it was 20%, think it's about right. So that's really interesting. Thank you. So I think I can see that we have had quite a few questions come in now. So I'm just going to hand over to Mark to go through those.
Thanks, Nikki. That was really interesting and quite an interesting contrast in different approaches there, I think. So we have got some questions coming in. Just looking at this first one, I guess this is one for Gillian. Gillian, you're in the position of starting a brand. So when setting up a new fashion brand, what rights would you focus on?
Yeah.
And what rights are you focusing on? I guess you're going through this process at the moment.
It's a really good question, and it's an interesting one because obviously as a startup, funds, there's no revenue at the moment, so the funds are really tight and we're having to watch our costs, but we are actually investing in our trademark on our name, and actually we have a very distinctive mark also that we're trademarking, which is a cost, but we believe that's actually a cost which is worth paying for. So we're also registering that in the territories that we believe we'll be expanding into in the next 2 to 3 years, and also in all the classes of product categories that we have already planned that we are going to be going into. So we have taken that quite seriously, and I think actually for our investor, it's set a degree of professionalism and commitment to our business and our brand.
So you're budgeting for different amounts in different years and building up with a clear strategy.
We are, and in discussion with my investor, he felt it was worth doing that up front and actually not waiting until we were ready to go into that territory. So we're already very clear as to what our roadmap is and what we're planning to, what countries we're planning to expand into.
Yeah, well, and actually on that point, hopefully what Bob was saying there reinforces the fact that that's the right approach. Yeah, fantastic. Bob, this next one looks like it's one for you. And I think you've touched on this a little bit already, actually, but in terms of global, worldwide marketing strategies, how widely would you advise applying for trademark protection?
Sure. So, obviously it depends on, a lot of this is driven by budget, as Gillian said, because it can get very expensive and different brands are starting from different place when it comes to budget and in level of investors and whatnot. So I always take that into consideration. But when I sit down with my sort of startup clients, we have sort of a frank conversation about that. And we usually will focus on the home market, of course, and what I consider to be the core markets. And I did touch upon it a little bit earlier. I think those would include the markets that you're already in, if you've already launched. And of course, that could be numerous. But so if you have to make determinations, you would look at your revenue from those markets. How important are these markets commercially speaking for the business? If you're not yet launched, where do you intend to focus your marketing efforts? Where do you anticipate to be those core commercial markets for you, where you might have, for example, the strongest sales? Certainly, if you're going to have a physical presence in more than one country on the ground, then that should be part of that consideration. Presumably, that would also be a core commercial market, but if not for some reason, then you might consider that. Like I know some brands have distribution hubs that aren't really local markets so much for sales, but they have a physical presence there. I would consider that. And also, I said this before, but I think manufacturing centers are really important too, for a couple of reasons. Sometimes factories like to register other brands' trademarks that they're working with. And they do that for various reasons. Sometimes, I've heard that they think it's something they should do, that the brand should do. But in that case, it should be, of course, registered in the brand's name, not in the factory's name. And when it is registered in the factory's name, that factory has a legal right to that trademark. And so if you want to switch factories, that could be a problem. So it's good to do that defensively, especially in countries that don't require use to obtain a registration. And then, of course, you expand from there. So even if your budget only allows for 1 or 2 countries, you might think, all right, well, these are my core markets. I know. I mentioned before, you do want to consider countries with high piracy issues. China is probably an example. I don't mean to pick on them, but it is an example of a country where sometimes brands don't have an immediate plan to be in China commercially, but it's money well spent. It's a relatively low cost trademark filing, assuming that you're not already blocked by a pirate. So I would recommend that.
Okay, and this next question, I think probably Gillian, this looks like one for you, and goes to an extent to what we've been talking about. And you'll have given some thought to this, I guess. But what in terms of cost effectiveness, limited budget, in terms of cost effectiveness for new brands, what are the most cost effective steps you can take?
Is that just in terms of your intellectual property, or is that just in general?
Let's keep it to intellectual property.
Well, I think I agree with Bob, actually. Having your plan in terms of where you believe you're going to be trading, what territories and what classes, but actually start with your home territory and make sure that you register the classes that you are going to be launching your brand in. And that is probably the most cost-effective way to start. We probably could have just trademarked our name, but we have a distinctive design feature, which we did debate because it obviously doubles the cost. It's 2 trademarks, whether we should do that. But we decided to do that, but we could have probably not done that and just reduced our costs. So there are stages, and totally agree with what Bob said. We just decided to go all in straight away.
Fantastic. And actually, the next question, which is one actually that I would have asked if it had come in. Johnny, you talked about the probability perhaps, of a new Copyright Act. Have you got any feel for what the time scale might be? When is that very likely, and what's the time scale? And actually also, what might you expect to see in it? What differences would you expect to see reflected? I guess, how does it deal with Coffermel questions?
Well, stuff like Coffermel, I think, is quite easy. Just a position needs to be taken. The key decision has to be whether we keep the closed categories of works that we have at the minute under Section 4 of the CDPA. So that would be one thing. But generally, I think it would be to look at the defenses and just look at the application of technology. All of the previous Copyright Acts, in fact, the original very first statute ban, the very first Copyright Act came in because of technological advancements. That is happening again, and I think drafting it now would have to also have an eye on the future, because we have no idea what it'll be like in 20 or 30 years. In terms of timescales, I have no idea. I'd be very surprised if it was within the next 5 years. I think it might be within the next 10. My gut would be that once Brexit has settled down in a few years, things may start moving a bit more. It has been discussed, and hopefully within 10 years, it's needed.
So, sorry, can I just follow up with that? So what do you think will come first, a Court of Appeal decision or?
I definitely think a Court of Appeal decision in Cofmel before we get a new Copyright Act.
Yeah. And that could sometimes lead me so that so we said earlier that actually Cofmel was the most significant decision in 30 something years. Maybe I guess it was 30 something years since 1987, and actually Leyland Armstrong, which was that previous case, that helped drive the 88 Act to come through. So
yeah, I think it just, we need to grapple with questions about liabilities for intermediaries and all that stuff. I mean, all these answers are out there in a patchwork of places, but they haven't been sort of put into a coherent whole. And I think that post-Brexit is actually a chance to do that. But we'll just have to wait and see.
Yeah, thank you. Just looking at the time, let's carry on. So we've got a couple more questions coming in. And this is one for Bob, and you may have alarmed somebody here, Bob. And so have you seen in China, have you seen these pirate registrations being used to prevent a legitimate brand owner who hasn't got protection in China actually exporting the manufactured goods back out of China to sell them in their markets?
Yes, I've seen that. What happens is the more sophisticated pirates will register their trademark registrations once they've obtained them with customs in China, and they'll use that purposely to interfere with exporting of manufactured goods as leverage. What they really ultimately want in the end is to sell you back your mark for an exorbitant amount of money. And so simply fighting in the trademark office sometimes isn't enough leverage. And I think I would say most larger brand owners, also the larger brand owners don't want to spend the money to encourage this activity. It's sort of like you don't negotiate with terrorists kind of mentality. And then the smaller brand owners don't have the resources, right? So they wouldn't spend it even if they had it. So it really is hard. And so what you end up doing is fighting and challenging these registrations in the trademark office. China has increased the verbiage in their rules and their laws over the years about bad faith filings, but the teeth still aren't quite there. When you get up into the court level, it tends to change, but by the time you get there, they've already probably spent a ton of money. So I have seen it up close. I've seen pirates send demand letters from attorneys threatening to sue you in court for using your own trademark and that they've registered in China. It drives brand owners to madness, as you can imagine, and it's a very frustrating scenario. But not to be cynical about all of it, perhaps to try to be optimistic. When I talk to my colleagues in China, my understanding is there's at least some interest in trying to fix this on some level. And I have worked with brand owners that have been able to successfully thwart the piracy, to cancel the registrations based on bad faith, and to clear this out. But I will say it is hard when you don't have the resources to fight that fight.
Yeah. And I guess actually, so a couple of things. It sounds to me like what we're talking about here is trademark squatting in the same way that cyber squatting was a huge thing 20 years ago. We still see some of it.
Yeah, I think that's the best analogy for it. It is a real thing, and which is why usually in one of my first conversations with new brands and clients, we talk about China, and I know it doesn't always resonate at the moment because there's so many other things that a startup brand is thinking about. But I always try to at least keep it in the conversation initially, because I've just seen it happen so much, unfortunately. And it is unfortunate when you see it and a brand doesn't really have, they're not a famous brand. It's much harder to show to sort of overcome these issues if you're not a big, large brand that's been doing this for decades.
Is it a question that ought to be taken into account when making first filings in other jurisdictions? You need to be almost putting China in your first tranche of filings?
I have advised clients to do that, yes. Obviously it's a discussion, and there's, resources, budget are there. I've had clients choose not to do that, and then it has become a problem, which is doubly unfortunate. But these are real. Budget is a real thing, right? You can only spend so much. So it's hard to. Everyone's got to make decisions based on what makes sense for them. But if there is budget room, and if there's not already a piracy issue before you file, I would recommend doing it. It's so much cheaper to file that application than it is to deal with all these other problems I've described.
Brilliant, thank you. Seems there's a common theme there about actually considering these issues and deciding on a strategy at a really early stage. Just coming through from everything Gillian's saying and from your experiences with clients in China. I'm conscious that it's just ticked past 5 o'clock, so I'm going to bring it to an end there. Dealt with most of the key questions that have been asked. I would just like to say to everybody, to the panelists, thank you very much. That was really interesting and really different perspectives. I hope it's been informative to those of you out there in the audience. There is a feedback form which you can click on and feedback. And we don't yet have a date for our next session, but the subject of our next Talking IP session is going to be intellectual property and comparative advertising, which is a subject we've seen quite a lot of activity around quite recently. So hopefully that will be interesting to people out there. So just finally to close and say thank you once again. Thanks, Gillian. Thank you, Johnny. And thank